Okay, I think we'll go ahead and get started. Again, good afternoon, everyone, and welcome to today's webinar. My name is Michelle Peterson, and I am the training manager for the Empire Justice Center. I do need to note that today's webinar is made possible by the New York State Attorney General Homeownership Protection Program. Before we get started, just to let you know how you can interact with us today, everyone has entered the webinar in a listen-only mode. If you have any questions on the material that's being presented during the webinar, enter your questions into the questions pane on your control panel. We'll be addressing questions both during and at the end of today's presentation. The materials for the webinar can be downloaded by going to the handouts pane, which is also located on your control panel. Here you'll find a copy of the PowerPoint, an additional handout, as well as your attorney affirmation form for anyone seeking CLE credit. We are issuing one CLE credit in the professional practice category. To receive your certificate, note your verification code on your attorney affirmation form when we announce it and come to my attention. You can either scan it and email it or put it in regular snail mail. Either way is fine. We'll also post the CLE code in the chat box. Attorney seeking a certificate of attendance, we can also provide that. Just send me an email directly requesting your certificate and I'll get that out to you. Also, at the end of the webinar, you're going to be asked to complete a webinar evaluation. So if you would take a moment to complete that, we would appreciate it. With that housekeeping out of the way, I'm going to turn it over to our webinar moderator, Becky Keiko.
Thanks, Michelle. So I'm really excited, actually, today to have Stephen Sharp from Legal Aid Society of Southwest Ohio. He has become a bit of an expert, a national expert, on these FHA loans and these DASP sales that are happening. So just to put this in a bit of context, we had a webinar on February 10th with Trina Kokalis out in Long Island, and she did a great job on giving us the basics of the defenses and claims that you can raise when you have an FHA loan, a homeowner walking in with your FHA loan, and they have certain servicing requirements that they must abide by. With these DASP loans, as Steve's going to go into, those rules are getting changed without really any notice to our homeowners, and so it's changed the playing field a bit. So that was really meant to be sort of part one. That webinar is recorded and on our portal, so please feel free to go to it and view it at when you have time. And today we have Steve, who's going to really dig into these DASP loans and the DASP program. So without further delay, Steve, please, thank you. Take it away.
Thank you very much, and it's really a pleasure to talk with you all. I've noticed a lot of names that I know on the attendee list, and that's really great, and I'm sure you all give me the any feedback I deserve on how I do today. So please feel free to ask questions in the middle. I'll try to get to your questions. We'll also try to set some time at the end to answer questions. But frankly, we have a lot to cover. There's too much to cover. So the PowerPoint is really designed to give some extra detail. So we may skip over some slides, miss some slides. But as I try to do, which is important because I think people pay attention most at the beginning, is tell you all the stuff you really need to know, or at least I think you need to know, right up front. And so let's start with that. So I think the main thing that I want to especially communicate to the lawyers is don't give up on FHA defenses just because the loan has been sold through DASP. So I'm not, as you know, I'm not a New York attorney. I'm going to talk about general principles, but my real punchline here is for legal defenses, don't immediately give up and think it's that all of those regulations and wonderful things that Trina did such a good job covering last webinar disappear, okay? And again, this is in supplement to some of the specific tools you all enjoy in New York with the settlement conferences, good faith, other things like that that we don't get in Ohio. So, and it's important, I think, because I know we have housing counselors on the phone, to quickly distinguish between legal defenses, which are obviously things you raise in court, versus loss mitigation options for FHA-insured loans. What I'm talking about are focused on my point here is about legal defenses, things to raise in court. I'd say that the situation is more challenging when you're thinking about what actual options are available to homeowners. But I think those things, I think as all of you would agree, are tied together, and I think it becomes more challenging when the loan is no longer FHA insured, of course, to get things that HUD has approved, and with the partial claim, HUD has to be part of. So that is a different issue. But really, if you're going to take anything away, the first point on the slide, I think, is key. And I think the other point is that this is really new, and there aren't much for decisions. So what I'm going to tell you, unfortunately, hasn't been tested for what I can tell, especially with appellate courts. So I'm looking to other people to, if you had experiences, please let me know. And that really comes back to my point about what I think, a little plug about legal services attorneys. And I'm a legal services attorney, and the important role that we play, and that is really not only helping our individual clients, and we're going to be focused on the individual cases here, but really it's a plug to share what you have learned, share the problems you see, and there are many, as you all know as well as I do, with DASP, with the people who are working on the policy issues at a state and national level. And if you have any questions about how to get plugged in, not only, I'm sure, could you talk to Ellie and Becky about it, but you can also call me. And that leads in point here, and that is, please absolutely feel free to call me or email me to talk about your cases. Frankly, I'd rather talk about your cases than have to think about my own cases. I think many of you know that. Here's my contact information on the first slide. I will also give you my cell phone number if you take a moment to write it down if you would like it. I'm very quick to answer on that. And I have been asked several times if this is a dummy number, and I think many of you on the call know that it is not, and that I am happy to talk about this because it's very important to me to really make sure that we develop the case law together. So number is 513-331-1074, 513-331-1074. So actually, I think I've covered the main things I want to cover, but why don't we jump in a little further with that. And again, I will monitor questions. I think Becky's going to monitor questions, and we'll do our best to answer what we can. So we're going to really break this down into three parts, and that is, what are the mechanics, what is DASP, heck, what does that even mean, some legal arguments, and then leverage in settlement, i.e. what do we do to try to actually solve these problems for folks. There's not a lot of sources out there for these cases, unfortunately. The National Consumer Law Center book, which I hope many of you have access to, has a chapter not only on FHA-insured loans, which you'll see is relevant to DASP loans, but also a discussion about DASP and its history. Despite the fact that HUD has sold over 100,000 loans totaling several $billion, there is very little guidance from HUD on the program. There is a website, which I have a site for here, which is extremely hard to read. If you have trouble navigating it, let me know. I don't run it, but I've been monkeying around with it enough to have a pretty good understanding of where things are on it. Oddly, I think the best piece of information from HUD is this webinar that they hosted back in early or late last year. The slides are the link. There's also if you actually want to listen to, I think, a multiple-hour webinar, you can do that as well, but I have not. So there's where we have for sources. So what does it mean? What is DASP? It goes under a few names. I think HUD has finally landed on distressed assets. Also call it the single-family loan sales. I've seen it distressed asset sales program too, to make it more confusing. But DASP is generally what it's been referred to. And simply put, what it is are batches of FHA loans pooled together and sold through a HUD-sponsored auction. HUD pays off the insurance claim, and investors, mostly private equity, purchase the pools. It's so simply put, it is in itself simple because it involves the early payment of claims for insurance purposes and new investors take over. It is, I think, the implications of that process that are more challenging than what actually happens. And so HUD then takes the position after the loans are pooled and sold that the loan is no longer FHA insured because the claim has been paid, and now the private equity companies have it. So if or in the rare cases when nonprofit buyers have been able to win the auctions, those folks have it. So again, if there are any questions about that, kind of what that means, let me know. Again, you can write it in, but I'll keep going. So that is the simple version of what is DASP. Freddie Mac and Fannie Mae have similar programs that we are not covering. Those are called, and their acronym is NPL, non-performing loans. I do want to call everyone's attention to the fact that very recently, FHFA, which is the conservator of HUD of Fannie Mae and Freddie Mac, announced a new program that not only involves principal reduction mods, but also enhances the loan sale process. So I think that is not part of today, but relevant for purposes. So let's move on. There's been a lot of advocacy going on DASP. I'll just kind of fly through these, but there's been at least two, and actually more articles about the program, one from the New York Times. Those are both very detailed. There has been pressure from Congress about the program, a great letter from Senator Brown's office, and I believe Representative Cummings, and then a larger member letter about the problem as well. And there have also been good analysis of DASP. And who I forgot to put on this slide is the great report that Empire Justice did, which I think is linked in the handout. One of the handouts, the Empire Justice report on foreclosures, and there's some chapters in there that talk about non-performing loans that I think are really quite good. So there's been quite a bit about it. So get excited is my point. I think your stories are incredibly important to the advocacy. What actually happens on the ground, I think that HUD is proceeding by virtue of people buying these loans for generally the investors purchase pools for a percentage of the dollar value of the loans. In other words, they're buying them on a discount, and that this will allow the purchasing lenders to come in and give better deals, and our stories and our ability to see what's going on the ground are really critical to addressing that. So let me try to add, we have one question about what happens with, how is this process legal given all of what the borrower pays for. And I think that actually fits into what the role of HUD is, and just a reminder about who HUD is and what they do. And fundamentally, HUD is an insurance company, but it's an insurance agency that is a government insurance agency. MMI program in order to create incentives for lenders to lend with the goal of meeting the housing needs of those families. And this is an explicit statutory goal. And so they're an insurance company. They cover losses for the lenders that make these loans. So because it is a government insurance company, there are strings attached in order to they're making the insurance payments, so they want to know and make sure that the borrowers that are insured are not going into foreclosure unnecessarily. This is also part of the statute. So in exchange for the insurance, HUD has put explicit rules on the lenders to avoid unnecessary foreclosures. And this is what Trina went on in depth, but I wanted to point out that this is important for our legal analysis for these cases, is that it is clear from the regulation that you cannot proceed to foreclosure until all of the regulatory steps are met. That's not only in the regulation, but also incorporated in the insurance contract, which are, as we pointed out in the last webinar, are still in the vast majority of FHA-insured loans. They are not, there is some issue with HUD removing that language for recent loans. We're not going to get into that, but let you know that that's still something that I'm working on. But for the most part, that limitation on foreclosure is also in the borrower's contract, which says, thou shalt not proceed to foreclosure or accelerate without satisfying the regulations. So it is an insurance. FHA puts insurance on the loan for lender loss, and in exchange, there are these regulations that the lenders have to follow. And so in general, HUD will pay the insurance claim after the lender completes the foreclosure sales process. That is how it has generally gone. But, and I have this cite thanks to Elizabeth Lynch from MFY Legal Services who pointed it out, what happened is Congress amended the claims paying statute to allow the early payoff of claims, so before kind of the end of the process. And that's where DASP fits in here. So starting in 2012 and ramped up in, 2010 and ramped up in 2012, DASP comes in to allow the early payoff of claims. So again, that's what we're dealing with, is that HUD, and so again, I think it's important just to remember what this is, because it is really critical to all of the analysis. HUD sponsors the auctions. Lenders can participate by selecting loans to include in the pools. Now, they're only supposed to include loans that are a certain number of months in default. I believe that's 6. But also, very importantly, loans that have had exhausted loss mitigation. Now, I will ask you rhetorically if you think you trust the lenders, what the lenders are saying, when the lenders are saying that they have exhausted loss mitigation, if that has actually happened. And I will let you all ponder that for a moment, because I think I have an answer which I think it's quite as often as the lenders say it is. Okay, but it is supposed to be really for loans where loss mitigation has been completed. And in a way, I don't really want to get into the politics of DASP, but if we really are dealing only with loans where every part of the loss mitigation waterfall has been exhausted and folks cannot qualify for anything, then losing the FHA involved may not be such a bad thing, because there would be no other way to avoid foreclosure. I think it's that assumption that is the real problem. So the loans are pooled together and then sold. And there are 2 types of pools. I'm not going to get into the distinction between the national pools and versus the NSO pools, except to say they are what they sound like. National pools include loans from all over the country. NSO, and neighborhood stabilization offering, I think. I don't remember exact acronym, but the punchline is those are pools that are drawn from particular areas of the country. So you may have a Southwest Ohio pool or a Northern Illinois pool. And so the loans in those pools are focused in particular areas. Now, there are some additional strings attached for NSO pools. I don't really need to get into those, because in general, they are strings that attach to the entire pool. So there are obligations the lenders have to do for the entire pool. But it's not, I don't know that it's worth going through in individual cases. So then the purchasers, the people who are going to companies that are going to potentially buy these, have a chance to review the information prior to the auction and then bid. And so generally then, for loans that are sold through DASP, the loan is generally assigned to HUD and then assigned from HUD to the DASP purchaser. And so there are a series of contracts Like I said at the very outset, there is very little HUD guidance on DASP. Where a lot of the relationships come in are through the contracts between the seller, the HUD, and the purchaser of the loan. And so at the end, HUD pays off the insurance claim for the loans that are sold. And once the claim is paid, HUD has positioned that the loan is no longer FHA insured, and importantly, that the borrower is no longer entitled to loss FHA-specific options. Now again, mitigation options are different than legal defenses. I just want to clarify that while we're thinking about this. That what is the result at the end of the loan? At the end of the DASP sale, that the loan, the insurance claim is paid off. The loan is no longer, HUD says the loan is no longer FHA insured. The lender, the new purchaser, can work with the borrower on options to avoid loss mitigation. But HUD's going to say that it's not options that are sponsored by FHA, and in fact, there is some guidance from HUD about what those options can be. There's a press release in April 2015 about what a DASP lender who purchases loans must review and offer. And so now, for post-April 2015 sales, lenders or borrowers must be reviewed for HAMP or something similar. Okay, so it's not exactly HAMP, it's HAMP or something similar. And now the delay in completing the foreclosure is lengthened from 6 months to 12 months post-April 2015. So there's a real distinction between loans sold before April 2015 and loans sold after. And again, these are items that are built into the contracts between the parties. It's my understanding. So I think here's a good place to stop and see if there are any other questions that people have that they want to raise. Again, the actual mechanics of this are not that complicated. It is, again, the early payoff of claims and the transfer of loans from one party to another, with the HUD insurance paid off in the middle. It is, I think, what this means for borrowers that's more challenging. Okay, so I think people are still processing, and we'll have some time for questions at the end, so I will move forward.
Steve, do you see the one about the specific, well, how do you know, I think that's important, how do you know whether the loan was sold through DASP?
Great question. I did not see that one. How do I know the loan was sold through DASP? We will get through that. Actually, let's take that one right now, because we are one slide away from it. So how do you know? Well, what you're not going to get, I don't think, probably not, is a notice from your lender saying the loan is no longer FHA insured. That has been a consistent ask from borrower advocates, and it has not been granted yet. I think before the loan is sold through DASP, that the lender should write the homeowner and say, we have considered you for everything, we can't come to an agreement, so we've elected your loan for DASP. Unfortunately, I do not control HUD or the world, and so the HUD has not done that yet or mandated that. So what you're not going to see is such a notice. How you will probably find out is that the servicer will mention at some point that the loan is no longer FHA insured, despite everything in the documents looking like it is FHA insured. So that is, I think, the main way people do find out is that those who apply for loss mitigation are told in the middle of it that it is no longer FHA insured. The Empire Justice handout that's in the handout section gives some great ideas for how to find out that the loan is no longer FHA insured if you are suspicious. One thing that may make you suspicious is if it is sold to one of the servicers who we know do this, like Caliber or Celine or Bayview, but that's not conclusive because sometimes some of them do service FHA-insured mortgages, so I don't think that is specific, but there are some ideas for finding that out. You can also call the National Servicing Center if you really want to know. as a little punchline, I will say how I handle these cases is to assume and continue to proceed as though it is. It is FHA insured until I am told not to, told that it is no longer anymore. And that's often an approach I take in cases. But I don't know that that is the best way to handle everything, especially if you're not involved in the litigation. But you should get some notices through RESPA about a servicer transfer, and you may get some tells from who it is transferred to, and there's some ideas for how to follow up on that. But unfortunately, the way people generally do find out is when they're told the loan is no longer FHA insured. But that's a really important question. And to make things a little more complicated, not that complicated, but a little bit more, on HUD just released mid last month what they called an age delinquency portfolio loan sale. This is, they have this on their website. It's for loans that are way behind, but 48 months might not be the farthest behind in my cases. So I know that some of you are dealing with those. So this is a loan sale. It is, I flag this because I'm still trying to figure out what is going on here, but I noticed that it is specifically not called DASP. And so my question is whether the limits from April 2015 apply. I think people should be, other people should be kind of following up on this and working on it as well, because this is brand new. The legal strategy, so I'm not sure whether this is DASP, but it sounds like the mechanics of it will work the same. The question I have, it's what's in the contracts, I guess, is the real question. However, importantly, the legal strategies that I'm going to talk about should still apply to it. So the age delinquency portfolio loan sale, we'll see what that is. And if anyone knows anything about that, please, 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 please let me know, because I am very interested. I'm having, Becky, are there any other questions to address right now?
There's just an additional comment that, and it's true in other parts of the state as well. In New York City, at least, the assignment of the mortgage to HUD and then to the buyer is recorded.
Okay.
So, but that doesn't necessarily mean that your homeowner is aware of it. It just means that it's public record. You can find it if you want to.
Great. And sometimes, I know that some people have seen that where it's not happened, but, I think as a general matter, that should be how it operates. I think this is important. There's another important question, and I referenced it quickly, but I think it's important to spell out because it's very important for advocacy purposes, which is how does the amount insured paid by HUD compare with the amount of the unpaid balance in the loan? That is a great question. So the loans are generally sold in pools at a discount. So they are bid by a percentage, I think, of the unpaid principal balance and the value of the property. So as you can imagine, it's usually a percentage. I think it started out, don't quote me on this, but I think it started in the 50s and has moved into the 70s. It's kind of been in that range between 50% and 70%, I believe, of the unpaid principal balance. But HUD pays off the whole thing. They pay off the full claim to the lender. And so I'm going to just throw this out, that one thing I think New York folks and other folks should think about is how to keep, if the selling lender, the lender that elects the loans, did not follow FHA loss mitigation, but get fully paid by participating in DASP, how do you keep them in the case? I don't know that that's, we're not going to cover that exactly, but I think it's something I want to throw out there when you think about what your claims are, because in that case, it's really that lender, the original lender who elected the loan through DASP, that's really been the problem, because, again, they get fully paid, and in cases like I'm talking, the particular defense cases, if they haven't done everything they need to do, it's really a problem. So I think you should be thinking about how to, I think, keep them in or continue to make them part of the story. So I think that's a really great question. I'm glad we put it back that way. Then the final last question, does the unpaid principal balance listed in the sales report include any accrued interest, escrow, and fees? I don't think they break it out that way. That's a really good question. The lender's claim will include that, and there's some limits about when lenders don't get all of the money they're claiming, which are pretty technical and I'm not going to get into, but I don't think the unpaid principal balance does include that. So let's move on. Those are really, really great questions. Thanks, everyone. So, oh yeah, we went through that, right? Okay. I don't need to tell you all some of the problems that are with DASP loans. I think you are pretty well aware of it, but we're seeing loans that have no business going in to the pools because loss mitigation was not exhausted. That's really my #1 issue. But we're also seeing really poor offers on post-DASP sale from the post-DASP servicers. Again, I don't think I need to talk to you all about the detailed problems, but those are the main ones. Bad things things that should have never gone in, going in, and not appropriate. Definitely not principal reduction offers for the most part, or not some pretty poor offers that we're seeing for folks. And we could probably just have a session where we talk about how bad those are, but we won't do that. So let's talk about what to do about it. So, what do we do? For the attorneys in the room. So I have a case with a loan sold through DASP. I am told now that the loan is no longer FHA insured. Should I just give up my legal defenses based on FHA regulations? And Trina went through those, but essentially the regulations that have specific steps prior to foreclosure that the lenders must follow. Should I just give those up? No. Don't just give up. Now, I'm not saying you're going to be successful, but what I really want to hammer home here is that your response on to the question of or to the finding out that the loan is no longer FHA insured should not be to simply give up. Now, so what does that mean? So how do we? Let's think about, and this is where it gets a little tricky. So let's try to think about why those defenses do not automatically vanish. And again, I'm not saying and this is again untested, and I'm not saying it's a slam dunk, but let's think about it a bit. So again, to think about, I think I posed it as a question, and I think you all can answer this from New York law, but if your borrower had a defense before the sale because the pre-sale lender did not follow FHA regulations, if that lender pre-sale could not proceed to foreclosure because it didn't follow the rules, why should that just disappear because of the sale? Why should the sale just eliminate that defense? And it's important because the regulations, again, like we went over, the regulations and the language of the contract incorporate. The regulations are specific, and the contracts that incorporate the regulations require very specific steps. And critically, there is a time window in which those steps had to be done. And it's also a time window, and it's a prohibition on acceleration until those steps have been done. So when those steps were supposed to be done, when the pre-sale lender was supposed to do the face-to-face meetings and notice and the evaluation, because of how the program is set up, the loan at that time it was likely still FHA insured. So if you think about it in terms of a timeline, after the borrower defaults, there are steps that the lender needs to take, and there are time windows in which it needs to happen. And that time window is also bound by acceleration. And what I'm telling you is that likely, and in many cases, most likely, the loan was still FHA insured during that window. And I think and I think there's, the NCLC manual goes over case law about what the impact of that is and how it's, the courts have generally upheld borrower defense to foreclosure if those regulations are not met. So the lender cannot proceed to foreclosure unless those standards are met. So if that's the case, why should the DASP sale eliminate those defenses if the loan was in fact FHA insured when that happened? Okay, so another way to put it is the pre-DASP lender had a lot to do before it transferred the loan. For example, if it's 8 months past due, the previous lender had to do at least 3 things, if not more. And so if that lender didn't do all those steps, then the requirements, the preconditions for proceeding with foreclosure have not been met. So I don't think I don't have a good argument on the other end to tell me why that should just vanish once the loan is sold. So does anyone have any, so that's, unfortunately, there haven't been any case, I haven't seen any cases wrangling with this, and I think it can get a little complicated. And again, I think that shows you why the presence of the previous servicer and lender is so important. So let me kind of let people sit on that for a bit. Does anyone have any questions or want to raise anything with that? So I'll let people type, and then I'll kind of might go quickly into this in this next point. Now, I think though what's critical in this is where I think the limits of that argument are on cases in which the DASP purchaser has brought the loan current after the sale. And I think this kind of will illustrate what my general point is. If the DASP lender, let's say a Caliber, then brings the loan current after the sale, and then the borrower goes into default, that no longer applies, because at the relevant time window, the loan is not FHA insured. But that's not the cases I think that we are seeing or that we're going to be having for the most part. For the most part, the loans that we are seeing in foreclosure were FHA insured at the time when all of this should have happened. What I mean by all of this is all of the regulations, all of these requirements, the 206, 602, 604, and 605 requirements should have happened. And I think that's really critical. And to get back to one point that Trina made in her excellent presentation is that you should think about these cases like you do with FHA insured cases, and my goal is to take the best cases, really focus, especially when the law is so up in the air, focus on the cases, I think, where not only did the pre-DASP servicer not comply with FHA regulations, but also where this borrower really should have gotten FHA loss mitigation option in that time period. So really you want to check for compliance. So what that means is your discovery will really be focused in, for the most part, on what the previous servicer did. So that's who you're really, that's going to be really the focus on, one of your main focuses in handling these cases is what steps did the previous servicer take in order to solve the problem. And what I want to tell you is that HUD guidance that I referenced earlier, the webinar, actually goes into and gives some, I think, very critical information for us handling these cases about what the DASP purchaser should have in its file. And if you look, the participating servicer, meaning the seller, is supposed to deliver to the DASP purchaser the complete collateral file. Okay? So I think in discovery, when the new DASP purchaser says, hey, it's no longer FHA insured, so I don't need to deal with you about this anymore. You can point out that these folks should have in their possession the information from the previous servicer. Now again, keeping this is another good reason why keeping the other servicer in is important, because if you have anything, if you have any discovery you want to do, and you can keep that the previous servicer in, it's much easier. But sometimes that's hard. And again, I think the webinar or the webinar that FHA has provided gives us some knowledge about what to get. So there's a question about opinion in standing on DASP foreclosures, and again, I think there's a lot of, I think this is a really good question, and the way I would break this down is, so often in our lawsuits, the original servicer files, and then the DASP sale happens in the middle, and so they try to figure out what to do about it. Unfortunately, I will tell you that standing law in Ohio is a bit of a mess, and so I think it's hard for me to know what to tell you about New York standing, but I do think that that's an important thing to look at, and can be maybe an easy way to really attack case, to think about it that way, because frankly, in Ohio, my experience when there's been a DASP case is that the lawyer for the lender is often quite confused about what is going on. Understanding. So I don't have a great answer on how that impacts standing in New York, but I think it's definitely worth thinking. I think there's, this is interesting. Jay Wall has this comment about how folks who are handling these cases should watch out for DASP and NPL purchasers from filing in federal court in order to get around the state court settlement conference process, and so they're in federal court. But again, I think that's what I will tell you is, if that is the case and they are doing that, that makes some of the legal discussions that we're talking about that much more important, because it gives you something to use and to address if you're in federal court. But I think that is a very important point. I'm glad you raised it. So I think the other considerations are, what other claims do you have? And I think that's really what you need to think about in terms of analyzing the case and how bad the facts are. And really, it's especially important. Again, I can't say this enough, but this is an emerging field, and the more people can focus on cases where really the borrower is supposed to receive something, the better. So I think about what other claims you have, and again, I can't say it enough, how else can you keep the original servicer in? I think these are issues to discuss on a statewide basis. I think they're really important, but I think having the concept of the really good leverage that has been developed across this, a lot of states about defenses to FHA insurance for FHA foreclosures, I think is a really thing to keep at the top of your mind. So, but that just doesn't mean you shouldn't, and I really would encourage people to think about every other claims that they have, especially statutory claims. And especially if you are going to be in a situation like Jay says, where you're going to be in which I cannot answer, but I have to say is, can I explain how DASP saves FHA money even though they are paying the full amount owed to the selling lender? What a great question. I'm not in a great position to answer that question as someone who isn't quite sure themselves. I think one practical way to think about this is that it allows FHA, and I think this kind of reinforces my point about what DASP is, it allows FHA to pay off claims earlier in the process rather than later. So they would complain about how long the foreclosure process takes, et cetera, et cetera. I'm not going to comment on what I think about that, but it does allow HUD to pay less. Now, again, they are paying the full amount owed. They're paying the full claim to the participating servicer, and I don't think that point. I think when you're talking about this program to judges, to others, I think that has to be a really key part of your discussion because of, especially when you have a borrower who has not received everything that they should receive. I think Catherine has a great comment about admissibility of testimony based on business records who took the loan after commencement of action. I think, so the punchline in the comment, and I think if you want to look at the comments, you can go ahead, and I think it's a good one, about what is required from the selling lender, or sorry, the selling lender and also the purchasing lender in terms of burdens of proof, rules of evidence. That all is extremely important and is really, when you have the concept that these defenses are still relevant and shouldn't be given up, then you get into those areas and the rules of evidence that are really important, because then you have to, like we talked about with Trina, prove your case, and the lender also has to establish their part of the case as well. So then the lender, when you have this concept that I don't see why the DASP defenses or the FHA defenses should just disappear under DASP, then you're back into a lawsuit and should start raising these admissibility issues, the evidence issues that are really important. Unfortunately, in Ohio, we've had some weakening on that, but hopefully there hasn't been that in New York. Well, keep asking questions. I'm going to move quickly on because I want to touch on relief because I think it's important and really comes back to, I only make a few points in these webinars really, which is don't give up. Be sure to share your stories with everyone, and be sure to think about good cases and leverage. This falls under my third point, which is think about good cases, because really the relief that your client gets depends on your leverage and on damages and what issues you can raise and what you can do about it. Now for housing counselors, I will just tell you, and I think it's important, but I think it's important for attorneys too, to repeat my point about HUD's position is that once the loan is sold and the claim is paid off, the specific FHA waterfall does not apply. And you know what you can do. This program is so new and the cases are so undeveloped that I hate to say anything about what you're not going to get and what's not going to happen, because maybe I'm not thinking creatively enough about it and maybe there's other ways to do it. But one thing that I think is important is that you can demand the modification that looks like FHA HAMP if you have a defense that if your client should have received FHA HAMP months previously and you have the ability to raise these issues in court. You know, one demand you can make is that the lender should craft relief in order to really give the borrower what they should have received. It's important to check your client's eligibility throughout the process, because you want to, by doing that, not only you develop the facts of your case, but you also develop what kind of relief your client should get. So you really need to check and really do a good job of thinking through at every point, especially pre-DASP sale, what your client should have gotten. But also, and this is, I do think for the housing counselors, I think it's really important to remember that there is HUD guidance on what the lenders should offer for post-April 2015 sales. And so I think 2 points there. One, be aware of that, and I don't know that that's something that lenders are actively giving and actively reviewing people for. But also, I think this comes into being able to isolate when the loan was sold and which pool it was sold in. So I do think the Empire Justice guide about how to get that information is really important, because you definitely want to know if you have a loan that is in the post-April 2015 sale, because then they should be evaluating your client for HAMP or something similar to HAMP. Now, I don't know that that's a perfect answer and something that will solve all your problems, but I think that's at least really important to know. But again, this comes back to my main point, which is really know your cases and handle them in a way that doesn't give up on FHA insurance defenses, because it directly informs what you can get for relief. That may be different than getting actual FHA HAMP, but maybe it's a way to get something good for your client. So let me answer some questions, and then feel free to type. We've got a few minutes to answer some more questions. There's a few more points I want to make, but I'll handle this one right now, which is what is the accountability for loss mitigation post-April 2015? Is there something in the contract with HUD that buyers have to self-report compliance with HUD, or once it's sold, does HUD care? Great question. In other words, what are the accountability for the purchasers, and what's the reporting requirement? What I will tell you is that there are reporting requirements. What they are exactly, I'm frankly not the biggest expert on, but what I think is really important is that whatever they are, I think we need to make sure that the lenders, are really doing what they're supposed to be doing, and we should be definitely raising these issues with HUD if we're seeing purchasers who are not doing what they're supposed to be doing, who are not paying attention to the rules. So really the accountability that we should be raising are both to the pre-sale and on the post-sale side. And which ties into, I know that's not a perfect answer. I think if you look at the announcement, there's some discussion. There's also, you can read some of there are some contracts. There's contracts that you can read between the parties. What I think is a real weakness is that I think there's too often HUD is not thinking about what the borrower experience is, and I think it is really our job as advocates to raise that to HUD, whether or not whatever the reporting they require from the lender. Which leads me to this point, which is I really want to hear, it's very important to me to hear how your cases are progressing and what's happening. I think there's a lot of folks who are working on this. There are people in your state who are working on this, and Ellie and Becky and others can link you there. But I'm working on it as well, and really would love to know what you're seeing, both in your individual cases and on a larger picture. So I think what I will leave with on comments is that this is, I fear, especially with Fannie Mae and Freddie Mac entering into the pool, into these sales as well, and HUD seeing these, that this is going to be a reality for our homeowners, this using sales of loans as a way of limiting costs and for having others to do loss mitigation. And if we're not on top of this now and really advocating, I worry that this is going to be our future, and that that this will be repeated in other ways. So I think it should be a really high priority for us as a legal aid community, and I know a lot of you think the same way. So let's see if there's any other questions. Becky, did I miss anything?
I think there's only one that was a little, just a little hard to kind of read through. So is the statement accurate to say that DASP enables private equity firms to obtain the discount the homeowners did not get?
Oh, I get it. That's really, yeah, I mean, I think that's, let me tie that in. I think that that's really critical and should be part of our discussion on this, which is HUD has taken the position in reading their statute, which I'm not going to say I agree with, but I think is their reading of the statute, that they cannot do principal reduction, that they are limited from doing principal reduction, either the statute or the regulation. Frankly, I can't remember off the top of my head, but we know that HUD has not done principal reduction, and they're taking the position that they cannot do principal reduction. So here we are with DASP, where a lender is getting a discount and HUD is paying the full claim. I think that needs to be part of the discussion of the case in two ways. I think it should be raised when you're dealing with bad loss mitigation offers to the purchaser, and is bolstered by any leverage you have in court. And I think it needs to be raised publicly in discussing this, that the borrowers who are underwater have not been able to get principal reduction through HUD, and yet here we go, they're selling them at a discount. So, and then if the punchline is the new lenders are supposed to be giving principal reduction, but they're not, I think that's an important story to tell. So yeah, I think that's a really good observation, and I think it all comes down to being able to talk about that. And of course, as Jay said, purchase price is fair game for discovery. You know, that's an interesting question. You can look at reports, the HUD reports, which are on that very confusing website that I included in the PowerPoint, talk about how loan pools are sold. I'm curious. I actually don't know the answer to if there's any more granular data on the sales amounts, but hey, you know what? I think it is fair game for discovery, as Jay's comment says. Were there any other? What other questions do people have, Becky? Were there any others that I missed?
No, you are pretty amazing, actually, incorporating the questions into your natural dialogue, so kudos to you. That's not easy to do. So there aren't any questions at the moment, so while people are typing those questions in, this is a great dialogue, and somehow between you and the folks asking the questions, this really actually turned into a dialogue, which is really difficult to do through the course of a webinar. So kudos to everybody on that. In the meantime, I want to just thank Steve. If questions come up, we'll answer them again. Thank you so much. Steve, I just want to make that extra plug in case you don't have enough work to do. I can tell you personally that when we have questions, people in my neck of the woods here in the real upstate part of New York, Steve calls us back immediately, is really willing to just offer whatever time you need to think these cases through. And so yes, he's amazing, and I really appreciate the time that you spend with those of us in New York trying to work through these issues as well. So feel free to reach out just as a third-party thumbs up. And then for those of you who are looking for CLE code, this is a CLE webinar. Feel free to send that over to Michelle. The code is EVT632. And then those of you wanting a participatory certificate for housing counselors, you also can contact Michelle and she will get that to you. Also, as a plug for the next two upcoming webinars, one is CLE based and one is not. May 18th, we will have Mark McCardle from Treasury Department to talk about the understanding the end of the Making Homes Affordable program, as we all know, that's coming to an end at the end of this year. And so all those deadlines and what that program is going to look like, that is not a CLE for our clients as we come to almost a 6-month mark. So, and then May 25th is a CLE, and that one's going to be a duplicate for those of you in New York City, but we're offering it for those of us upstate. It's a refresher on basic property law concepts. It's been a long time since many of us have been in law school, and so these basic concepts are quite helpful when we're actually dealing with property issues, right? So that's coming up. There's no other questions, just a general great webinar. Thank you from one of the participants. And so again, to everybody, have a great afternoon. It's 1 o'clock. Enjoy the rest of your day. And again,
and thanks everyone. Again, please feel free to give me a call and let me know. Again, like I said, it is more fun to work on your cases than my own sometimes, so I appreciate it. Thanks everyone.
Thank you everybody. Have a good day.